Now, Chief Justice John Roberts said that for too long, universities have, quote, concluded wrongly that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice. Justice Clarence Thomas, the nation's second black justice, who had long called for an end to affirmative action, wrote separately that the decision sees the university's admissions policies for what they are: rudderless, race-based preferences designed to ensure a particular racial mix in their entering classes. Justice Sonia Sotomayor wrote in dissent that the decision rolls back decades of precedent and momentous progress. But that now means institutions of higher learning have to look for new ways to add more diversity to its student bodies. Well, some students from Harvard had this reaction to today's rule.
Well, I'm from Wareham, Massachusetts, and it's like a small town. Schools with like underfunded high schools and stuff tend to have more students that happen to be minorities, and I think that those students deserve to have a chance at getting into a school like Harvard.
I'm infuriated and speechless. This is just racism. It's just racism with a very thin veil.
It feels like the court has been within a sort of trend of taking rights away lately. And it sort of feels like this may be another one of those types of blows.
President Joe Biden weighed in on the High Court's decision, saying the U.S. cannot abandon its pursuit of a more equal higher education system, adding they must be committed to creating diverse student bodies. All right. Still with me, litigation trial attorney Rich Schoenstein and criminal defense attorney and civil attorney Jesse Law. And joining us now is U.S. discrimination and constitutional lawyer Andrew Lieb. Andrew, great to see you. Thank you so much for joining us. And I'll start with you. I've got to get first a reaction to the ruling, but I'm going to ask it this way. You heard a student there. They're, our best and brightest from Harvard. One of them says, it seems like the court is taking away rights, that they've been doing that. Is that what you see this decision as?
I don't, Michael. I do think that this could feel that way to a lot of people, but you have to go through the 237 pages. And Justice Roberts, who writes the opinion, says that race can remain a factor for the individual, meaning that how does race influence the character of the individual? And to remind everyone, when there was oral arguments, we actually heard that question about admissions letters and how are you going to deal with that? And Roberts is basically saying race can't play it because you're this race, but if it's influenced your specific character, it can be a factor moving forward for you as the individual. So I want all those students that are upset about it to remember that important line, Michael.
Yeah, I think you're right. I think there's still some room for that type of thing. One of the problems that I've read about with this decision, and I want to get your thoughts on it, is that they were particular to race-based, and I think that was the issue in front of the court, race-conscious choices by these universities. But there are a number of other ways folks get in this type of preferential, if you want to say, where they look at donors, where they look at legacy folks, where they look at folks who are related to faculty or employees of universities. They all get a certain level of preferential treatment at admissions, but those were not addressed by the court. Do you see that as an issue?
I see that as a civil issue in common parlance. I don't see that as a legal issue, Michael. And the reason is that this case was brought on the Equal Protection Clause when it came to UNC, and it was brought on Title VI when it came to Harvard. Harvard's a private university, so it was about funding. And both those clauses don't address having a donor, and they don't address having money. And while we all don't like that stuff, and we'd like an equal playing field overall, and we say, why are we getting rid of race and not dealing with these other things? We don't have a law right now about that, and I would call on Congress to hear everyone complaining about that. And perhaps we should have things. We go back to those admissions scandals to remind you of all those parents that were brought up on charges for playing the game wrong. And I think your statement is more about the parents that are doing it above board legally, but why is that legal that you're able to donate a library and get into school? Michael, I think you bring up a very important point, but those are not disallowed under current law, Michael.
Yeah, well, New York, it's interesting, has just introduced a law seeking to make those illegal as well, not allow those in admission. So we'll see how that makes its way through the legislature there. One last thing I want to check, and then I'll check in with my guest here, Andrew. One of the things that Chief Justice Roberts says, and I found it interesting, because I can remember back in some of the earlier rulings involving affirmative action and race-based decisions made by universities, was that this type of plan had to have some end. There were a number of things mentioned by the court. And he says it lacked, these programs by these universities lacked sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, and involve racial stereotyping, and lack meaningful endpoints. Is that a suggestion by the court that the right program with the proper sort of following some of these, these warnings by the court could pass muster by the Supreme Court?
Michael, I'm loving you right now. That's how I read things. Every closed door is an opening for a new door. And what I need to point out is that Grutter, which is the precedent decision, said in a certain amount of years, 25 years, we might not need this anymore. And the problem with this case, as they're saying, is UNC and Harvard had no end date in their program. And then the secondary issue is we learned, and I hate to upset these Harvard students that we saw in the previous package, but it wasn't about making minorities having an opportunity. Instead, the whole point of the affirmative action was to have a more robust exchange of ideas for everyone at college. And what they said is, how do you measure that? How do you know that? Where are your objective findings? So the law firm of Michael and Andrew are going to come to all these colleges now, and we're going to suggest to them, have an end date, have your social scientists come up with how this diverse body would increase specifically through statistically significant correlations, a more diverse exchange of ideas, and wham, bam, we've solved your problem. And I think Roberts opens that door, Michael. Brilliant of you, Michael.
I agree 100%, and that's the good news from this decision. Rich, I want to get you to ring in on this. Love to get your thoughts or a reaction to the Supreme Court's ruling.
So I hear you guys. If your point is this decision isn't as bad as it could have been, I guess I have to agree. But make no mistake about it. Here we are again with this Supreme Court. They are a radical, activist Supreme Court. They are throwing away decades of precedent and conduct and the way we were doing it. This Supreme Court does not care about precedent. They don't care about your feelings, and they don't particularly care about the Constitution. They are dead set at writing the rules the way they want to write them on all of these issues that we saw last year and we're continuing to see this year, and I assure you there is more to come. So not as bad as it could have been, but pretty bad.
Yeah, I would have to agree. And I think Ketanji Brown Jackson and Sonia Sotomayor mentioned very similar comments or sentiments in their dissents. That's a problem here, that they're overturning precedent after precedent. Finally, Jesse Lal, I want to get your thoughts on this momentous ruling by the Supreme Court.
I agree with Rich. I think this U.S. Supreme Court, although well-intentioned, is completely detached from reality. We still live in a nation where we strongly strive for diversity. There are many, many areas where we have to close these racial gaps and and provide solutions for past wrongs. And I don't know if this is a timely decision. I hope that the universities will be able to reevaluate their procedures and consider diversity as a very pivotal factor in their admissions, although their admissions decision won't be based on race. It's a very difficult decision to make. I don't know where they draw the line.
Yeah, they've been creative in the past. Hopefully they'll come up with other ways, because I think we all agree diversity is an important part of higher education. I don't think you can deny that. All right, Andrew Lieb, thank you so much for joining us. Really, as always, appreciated your insights. Jesse and Rich, you're going to be sticking around. Folks, the jury reached a verdict in the Parkland School cop trial after nearly 4 days, 19 hours and 25 minutes of deliberations. And he was found not guilty on all charges. Do you think the jury got the verdict right or wrong? Up next, we're going to read your comments left on our Court TV social media pages. Keep it here on Court TV.
A started hearing these stories about murder.
Go deep inside the dark world of true crime.
We knew that what we were doing had consequences, but we just didn't care.
Vice on Court TV, next.
Tonight on Closing Arguments, the case against Alexi Treviso.
We discovered a dead baby in the bathroom.